okay, in terms of section 31(1)(a)(1). Yeah. So you can see you have that 12-month, but it is extendable to 15 months. But important to note, this is only where it is a South African priority, where you're filing a South African complete patent application. Okay, so your South African complete application then, with that you will file your complete patent specification with the claims, along with all the supporting documents that are required in terms of the Act and regulations, and we'll touch on those a bit later on. This is just to give you a brief overview of the process that takes place. Once you file the complete application, you need to get your application in order within 18 months of filing the application in South Africa. Okay, so within 18 months, this application must be in order for acceptance. That means that if there is an outstanding proof of assignment for invention, so in terms of the Act, you need to provide proof of the assignment. So if an inventor, so I that work for Spoor & Fisher have invented something, but I assign it to Spoor & Fisher and they are the applicant, they need to show that transfer of the invention to Spoor & Fisher. Okay, and that's normally by either course of employment, so in my employment contract, or by way of a deed of assignment that actually sets out that transfer. So all the requirements in terms of the documents that are necessary need to be completed within that 18-month period. The other deadlines that are also important is that you need to submit supporting documents such as a Form P3 and a Form P26. But we will touch on all of these a bit later on, but their deadline is 6 months from the filing date for South African applications. Okay, so once the application is in order for acceptance, the Patent Office will accept the application. So they will give it the stamp of approval that they accept the application and that they are happy for it to proceed to grant. So they will issue this notice of acceptance. You are then required to publish the notice of acceptance in the Patent Journal. And the Act requires that you need to publish the acceptance notice read together with Regulation 46. You need to publish it within 3 months of the date of acceptance. Okay. Within that 3-month period, once you've arranged for the publication, the Patent Journal publishes, and your acceptance is also published in that Patent Journal. And that is when the patent becomes granted, okay, and is open to public inspection. Okay, so remember, this is all within the South African framework. So if we run through that again, just very briefly, you'll file a provisional application. Within 12 or 15 months for South Africa, you file your complete application. All your formalities need to be complied with within 18 months, although that is also extendable. Just remember that you can make an extension to the Patent Office to grant you more time, should you require more time, and to ensure that they don't accept the application. They'll then issue the notice of acceptance when it is due, and within 3 months of that acceptance, you need to ensure that it is published within the Patent Journal. Just out of interest, the Patent Journal is generally published the last Wednesday of every month. And then your 20-year monopoly as to when the rights vest to the applicant or the patentee once it's granted is from the filing date of the South African application. So from this filing date, yeah, you have a 20-year period within which to monopolize the invention and exploit it. Are there any questions on this so far? This is just a very brief overview so that you have an overall understanding. We will go into a bit more detail. Okay, no questions on this part so far. Lufuno, you have a question for us? Lufuno, I can't hear you.
apologies. Now can you hear me?
You very faint, Lufuno.
Marco?
Unfortunately, can't hear you, Lufuno. You seem to be muted, Lufuno. Let's see if we unmute you.
Can you hear me now?
That's better, yes?
All right. Okay.
Yes.
So you said the protection starts from the complete. I was under the impression that it starts from the priority date for the provisional.
No, so your rights are only granted. Remember that there are no rights that grant from the provisional application. The provisional application only secures you that priority date. So that is when the court will look at your novelty and inventiveness. They will turn to the provisional filing date, the priority date. But the monopoly period, when you have those rights granted to you, are from the filing date of the complete.
Okay, thanks.
Okay. And some of the reasons why you would file a provisional application is, again, as I mentioned at the start, was for the allowance of time to do some further market research to see if improvements need to be made on the invention, to obtain funding to further develop it, to seek opportunities to enter the market and to build up your resources necessary. So that's generally why you file a provisional application, and also to secure that priority date so that you are able to disclose the invention after the priority date. So that's the importance of filing the provisional application and why you then still need to actually complete it. Bianca, you have a question?
Michael, I'd just like to know how it works in patents regarding then the date of patent. Like, is it the priority date? Does that become in the register, like the date on, like, is it, I know it gets registered, but do we work then backwards on that patent certificate? Is it then, what date will then be issued?
So your patent, once it's granted, so the date that it's published in the patent journal is the date when the patent is granted and issued. But the rights are enforceable from the filing date of the complete application.
Okay.
So the enforceable rights retrospectively work from the filing date of the complete application. Okay. But it's only granted once it's published in the patent journal. Okay, so if we then...
yes. And only just for a South African provisional?
Yes.
Okay.
So this part in particular applies only to South African provisional. So if we move on to the foreign, so a Paris Convention application. So say somebody in America has filed for their invention in America. That application is considered your priority application in America. It's the first application that was filed for that invention, and this is in America now. But they seek to obtain a patent in South Africa as well for the same invention. So they will, from their provisional application in the United States, then file a patent application, but claiming that priority date in the application for the South African application. And that also needs to be done within a 12-month period. So say they filed the application in America today for the priority application, so the 3rd of May. They then need to file the complete application in South Africa to have a valid claim to that priority by the 3rd of May 2022. Okay, so if they're filing today in America, in terms of the Paris Convention, they have to file within 12 months, okay, to have that right to priority. Remember the Paris Convention? The first objective was that right to priority, and that's where this falls into the picture here. So within 12 months, they need to file. But the difference is between South Africa and a Paris Convention application is that there's no 3-month extension available to foreigners. Okay. So they have to file within 12 months. If they miss that deadline, then they don't have a claim to priority rights. And if that document is publicly available in the United States, it will destroy the novelty of their South African application. Nomkosi?
Hi, Marco. Sorry to take you back to the South African application. I just wanted to clarify if the applicant has the onus to publish the notice of acceptance within 3 months.
Yes.
Does that mean the patent is only granted after 3 months, even though the notice of acceptance was issued 3 months earlier?
Yes. Look, once the notice of acceptance issues, they can publish it within the next patent journal. They don't need to wait the 3 months, but they just need to ensure that it is published within that 3-month period. If they don't publish it within the 3-month period, all the rights are lost. So you must imagine they've gone through this entire prosecution, this entire development of the invention, and if they miss this step, all the rights are lost. There's no way of recovering those rights. And you'll see that there's actually a case that deals with this, and we're going to touch on that very important case a bit later on. But your rights are vested from the date of the complete application. So even though it's only published a bit later after acceptance, you can enforce your rights from the filing date of the complete. So if somebody were to infringe your patent during this application phase, once it is granted, you can still enforce your rights on an infringement that took place during this period. Okay. So it's not a disadvantage if that's what you consider, if that's what you're thinking. Does that answer your question?
Yes, it does, Marco. Thanks.
Okay. But then if we just go back down to the Paris Convention application, you'll file your complete application in South Africa, and then it's the same prosecution that takes place in South Africa. You still need to comply with all the formality requirements of, all the documents that need to be supported in support of the application. Prosecution in South Africa is extremely straightforward, because unlike with the other patent offices across the world, South Africa doesn't conduct substantive examination. And what that means is the South African Patent Office doesn't look at whether the requirements of patentability have been met. So they don't conduct a search to see whether the invention is new or not, or whether it is inventive. The Patent Office in South Africa merely examines the application for the formality requirements. So have all the formality requirements been complied with? It's then the onus of whichever party alleges the invalidity of the patent to bring an application to revoke the patent. So there is still an enforcement of those rights later on, but South Africa doesn't conduct substantive examination yet. Very importantly, I think we have some CIPC officials here with us today as well, and future examiners, because the Patents Act is in the process of being amended to introduce substantive examination, where the officials at the Patent Office and examiners who are highly technical in their fields will actually start examining the patent substantively to ensure that there is compliance with the patentability requirements and issuing their reports for patentability. So it is a very exciting time for South African patent law, because there's a drastic change that is coming to the fore with the introduction of substantive examination. And I think some of our examiners are sitting on this workshop as well. So we really look forward to that and think it's very good work that you'll probably be doing in the future for the country. Okay, so is everyone okay with this slide? Do you have a good understanding? This is, as I said, just a very brief overview of the prosecution that will quickly take place in South Africa. Just remember that this application that comes from America, as an example, yeah, you know, the laws are different, as I mentioned earlier. You know, there might be method of treatment claims for an invention. So during this prosecution, it will be the patent attorney in South Africa or the agent in South Africa to ensure that there is compliance with the South African legislation. So when this application is filed or before it's filed, the South African patent attorney will assess this patent document to see if it does conform with South African law and suggest any amendments to bring it into conformity with our law before it proceeds to grant. Okay, now if we move on to a very busy slide again as well, this is just the PCT and national phase application that takes place. So the PCT, as you may recall from this morning, is the international treaty with 153 countries that belong to PCT, where the process to obtain your patent rights is streamlined. And it also gives a very good indication of your success of obtaining patent rights across the world in different countries. So again, the applicant will file a provisional application in whichever country they are residing in, or where they choose to file an application depending on the laws. And in terms of Article 4 of the Paris Convention, they need to file the PCT application within 12 months. Okay, so from the provisional, 12 months within which to file a PCT international phase application. So very similar as to how you would follow a convention application. And this is filed by the international or to the International Bureau or the receiving office, whichever you may like. Okay, so within 12 months, this application is then filed at the International Bureau. And within 16 months from the priority date, okay, it's very important when you're dealing with national phase applications to draw a distinction between which is the priority application and which is the international application filing date, because all these dates are calculated differently. So you'll see after 16 months from the priority date, so over here, so 16 months from this date, the searching authority will issue you with an international search report and written opinion. So this is basically during that international phase where they have conducted substantive searches and examinations to see whether there is whether the requirements of patentability have been met. You know, so is the invention novel? Is it inventive? And is it applicable in trade or industry? So they will conduct this international search and they will issue the search report and written opinion. And the examiner will either state whether the claims are novel or not novel, whether they're found to be inventive or not inventive. And you then have an opportunity during this international phase to argue the opinion of the examiner during that international phase. So say they mention that your first claim is not novel. You have the opportunity to argue it and say why it is, and that you wish to amend your international application in order to ensure that the claim is novel. And there are different ways of doing this, okay? So generally multiple claims are filed with the patent specification. So it might be found that the first claim isn't novel because it's quite broadly worded. but that the third claim does contain a novel integer. And how you would then achieve the novelty is by amending the claims to incorporate claim 3 into claim 1, so that you have this novel integer in claim 1, and thereby rendering that first claim novel. And that's how you would likely overcome an objection that is raised to novelty in the international phase. But this is really beyond the scope of what's necessary for you to know at this stage. Okay, but just so that you have an idea as to what I mean by what I'm saying. Okay, then within 18 months, the application is published on patent scope. So all the documents that were lodged in support of the application, the international application that includes the specification, claims and drawings, are then published online and is freely accessible to the public. Within 22 months of filing the provisional application, this step over here, the demand, is an optional step that the applicant can request. And this is generally where they have again amended the claims and they wish for a top-up search to be performed by the searching authority. So during this stage, they may have made changes to their specification, which they want to include, and which they wish a further search to be conducted to see whether it again complies with the patentability requirements. But this step is optional. But when you file your PCT application, you will always be issued with a search report. So it always undergoes that initial examination. But this top-up examination is an optional step to the applicant. And once it's followed that process, if you do go for the demand, the searching authority will issue you with your IPRP, which is your International Preliminary Report on Patentability, which is basically an extended version of your search report and written opinion. So for those applicants that don't file a demand, their ISR and WO becomes the IPRP. But those that do file a demand will be issued with a separate IPRP, again with further comments on the patentability of the invention itself. So that's all happens during the international phase at WIPO. Okay. Then within 30 or 31 months, the applicant is required to file a national phase application. South Africa follows a 31-month deadline. So for all foreigners that have filed a PCT and they wish to file in South Africa, they have until the 31st month deadline within which to file the South African application. And that is again from the provisional filing date. And this is why I say it's very important to remember these dates, is that your national phase entry date has to be filed, or your national phase application has to be filed within 31 months from your provisional application filing date. Okay, so from this get-go, yeah, 31 months to enter this step. Other countries have a 30-month deadline. So as a patent attorney, if your client has followed this route and they wish to enter national phase overseas, they need to be very aware as to when to meet this deadline, when they need to file the applications in separate countries. Okay, so basically how this then works into enter the national phase is that you will instruct a patent attorney in whichever country you wish to enter, and you will ask them to nationalize this PCT international application so that you are able to then obtain territorial rights in each country where you seek protection. Okay. And then it will follow the normal prosecution that is required in that country. So if you're looking at a South African application, it will then follow the same prosecution as it would have here. So I know it does seem a bit confusing and there's a lot to remember here, but it is very important just to remember all these dates and the steps that take place. When the national phase application is filed in South Africa, so say the application is filed today in South Africa, the 3rd of May 2021, the actual filing date of that application from when your rights exist when it grants will be the filing date of the international application. So your rights are enforceable upon grant from the international phase filing date. So not this date, yeah. Okay, not the national phase filing date. Your 20-year monopoly comes from the international application filing date. Sipokazi, I see you have a question for us. Sipokazi, I can't hear you.
Yes, Marco. I wanted to know, is the 22 months after the publication of the international application from the provisional application or from the filed PCT application?
That's also from the provisional application. So all these dates in this dark blue color, that's all from the provisional application dates.
Oh, okay, thank you.
Okay. And the publication is at 18 months. Okay, so this step, yeah, is at 18 months. You have to request your demand by 22 months.
So if one didn't request a demand from the publication, so would they now jump to the national phase?
Yes, you can.
Okay.
Yeah, you can.
Thank you.
No problem. Are there any further questions on this slide over here? Okay, do you want me to recap anything? Show of hands, just raise your hand if you want me to recap. Okay, so we've got a few hands there. Okay, let's just recap. Thanks, everyone. So let's just recap this PCT and national phase stage again. So the provisional application is filed in whichever country the applicant files this provisional application in. They then have to file the PCT application within 12 months in terms of Article 4 of the Paris Convention. So it's the same as with any one of these applications where you have to file the application within 12 months. Okay, because remember, this is actually where your rights will stem from. It's from this international application, which is what's granted. Because it's this international application, this international specification with those claims is the same as what is filed in South Africa when it enters the national phase. Okay. Then during this period, the substantive examination takes place where the searching authority will assess the invention for patentability, and they will issue the applicant with a search report and written opinion. The search report will set out any prior documents which they may consider prior art. So if there's another patent that relates to the same invention, they will actually cite that document so that you can go and have a look at it yourself. And they will issue you with their written opinion, which is exactly that. It's their opinion as to why the claims are deemed to be inventive or novel or not, depending whatever they argue. You are then allowed the opportunity to amend the patent application in the international phase to overcome any of these objections that are raised in the search report or written opinion. And then just to see this step, yeah, within 18 months from the priority date, the international application is publicly available. It is published online at PatentScope, which is the WIPO website. Then the applicant has the option to request a demand where they may again want to amend the application during the international phase, and they wish for those amended claims to be examined to again see are those claims in compliance with the patentability requirements. But this is just an optional step that the applicant can take if there is an amendment to any of the claims that they wish to have a top-up search conducted on, and a more in-depth search for that fact. Once a demand has been lodged and the top-up search has been conducted at the searching authority, they will issue you with your international preliminary report on patentability, or your IPRP, which is analogous to your search report that they would have previously issued. But it is in light of the amendments that were made for the demand. If this step doesn't happen, your ISR and written opinion is considered your IPRP. Okay, your IPRP will include this exact report. Okay. So once it's gone through this entire phase of the search, of amendments being lodged, of a top-up search being requested, and the IPRP being issued, the applicant will then choose to enter the national phase. And you can see the benefit of following the PCT route, because it's far more global. So you can, at an early stage, before entering all these countries across the world where you seek patent protection, you have an opportunity to get this international search report, which already gives you an indication as to whether your patent will be valid in the countries or not, whether it falls foul of the patentability requirements or not. So if at this stage the applicant sees, look, the objections to this invention are really bad and I'm unable to overcome those objections, then is it worthwhile filing this application across the world, because my patent is likely to be invalid and contested. You know, but if it is a positive search report or IPRP and it looks favorable to the applicant, then they have a good indication that their patents will be granted across the world. And it obviously also just buys the applicant a lot more time for whatever reasons they may need more time for. Okay, but then the most important here to remember as well is that within 31 months of the provisional filing date, they have to have entered the national phase in South Africa. And as you can see here in bold, for South Africa, you have up until 34 months to file the national phase application. But that is again upon request. So it's not as of right where you can just lodge after 31 months and between 34 months. You have to request the registrar to allow the late entry into the national phase in South Africa. Okay. And then the normal prosecution takes place as it normally would in every country. Everyone happy there? Hi, yes, Kangwelo.
Marco, I just wanted to find out what happens to those countries which are not part of convention.
Of the PCT or the Paris Convention?
Of the PCT zone.
So of the PCT, if they're not members of the PCT, then they will have to file via the Paris Convention following this procedure, yeah. So they can file a Paris Convention application in those countries that are not members to the PCT. Look, as I said, there's 153 countries that are party to the PCT, so it's probably 3/4 of the world is a member of PCT. And some of those countries that aren't have their own regional structures as well that they can follow. You know, for instance, UAPI, which is the more French-speaking territories in Africa. Then there's also a REPO, which Zimbabwe is a party to, for instance, and a few other countries. So there are different treaties and different filing processes as well that can be followed. But we're just looking at this from a South African perspective and what South Africa is party to. You know, there's also the European Patent Convention, which also allows you to file a single application in Europe and to designate different countries within Europe. So there are different mechanisms to follow.
Thanks.
No problem. Yolandi, you have a question?
Yeah, my question is, when you talk about the entering the national phase, is it when we apply for South African national phase, why do we apply for South African national phase, and what is the benefit of that?
So the reason why you have to apply for the national phase is because the international application doesn't grant the applicant any rights. It just streamlines that process, and it allows the applicant that opportunity to gather an international search to be conducted and to see whether the application is patentable or not. And then at a later stage to decide, is it worthwhile to file a national phase application or not? So this whole step here, this bit here at the top and to this IPRP stage, that all occurs at an international phase. That doesn't happen within South Africa. Okay. So once it's gone through that international application, the applicant has to enter a national phase in all the countries where they wish to obtain a patent. So whether it be America or China or Australia, they have to then instruct a local attorney in those countries to file the PCT application in that country as a national phase application. And only then are those rights granted to the applicant once it's completed the prosecution in that country.
So then it means that the first South African patent falls away, which we've applied for. Like we start off, before we go through the process, you start off by filing your provisional, right?
Yes, okay, but this can happen. This doesn't necessarily need to be in South Africa. And remember, no rights come from a provisional application. So whether you do this in South Africa or America, a provisional application will never grant you rights. It's only to secure that date of novelty and inventiveness.
All right.
Okay.
Okay, thank you.
Pleasure. Okay, I hope that's understandable for everybody. So I know it is quite a bit to take in these processes, but it is very important to have a good understanding of this. Okay, if we now move on to the form of the application for provisional and complete applications. If you have a look at section 31, most of the upcoming slides now are basically just going to be a regurgitation of what is in the presentation. There's not really much for me to explain to these. It's quite straightforward. Where necessary, I will touch on a specific topic, but do excuse me if it seems like a bit of a bore, which it may be in most cases, yeah. Okay, so, but it is important to know what the requirements are for an application. So it says in section 31 that an application for a patent shall be made in the prescribed manner and on the payment of a prescribed fee, and shall be accompanied by a provisional specification or by a complete specification. Okay, so we've spoken a lot about a provisional and a complete application. Remember, it's not obligatory to file a provisional application. You can file a complete application if you choose to, without filing a provisional application. Okay, but that just grants you that date of priority and buys you a bit more time to do whatever research you need to do or to make any developments. Okay, Then Regulation 22 says that an application for a patent, whether it be the complete or provisional, needs to be made on Form P1 and will be accompanied by the following documents. So your P1 is your application document, which just has the details of the applicant, the address, and what it is that they're looking to obtain protection for, with the title of the invention. And that must be accompanied by your P2, which is what becomes your register page. So if you have the printout in front of you of the presentation, or no, sorry, of the exam from last year, you'll see the last page from the exam from last year has a copy of the register page. So you can just have a look at that for your reference. And that sets out the bibliographic information. So again, who the applicant is, what the filing date is, what the priority application details are, who the inventors are, and who the address for service is. Then a declaration and power of attorney on Form P3. This is a very important document that needs to be submitted to the Patent Office. And the reason why the Form P3, as well as the Form P26, oh, sorry, it's not yet, but the P3 and P26 are very important documents because the P3 is a declaration that is made by the applicant. And in this declaration, they confirm certain averments that are being made, that the applicant is entitled to the invention, that the inventors listed on the P3 document are in fact the inventors, and that the applicant has acquired the rights to the invention. It also states that there's no lawful ground that the patent be revoked. So the applicant needs to sign that P3 and submit it to the Patent Office within 6 months from the local filing date in South Africa. And again, why the document is so important is because if one of those declarations that are made on the P3 or P26 are false, the patent can be revoked. And you'll see that tomorrow from Section 61. So it is possible to revoke and invalidate the patent based on a false declaration being made in terms of the P3 and P26. Are there any questions?
It's within Form P2 must be submitted within 6 months after?
The P3 and P26 need to be submitted within 6 months of the local filing date.
Thanks.
Pleasure. Are there any other questions so far? Okay. Okay, then I mentioned this earlier as well, that you need to show the applicant's entitlement, because remember, it's not necessarily the inventor that will be the applicant, because a lot of inventors are employed by companies to conduct R&D, their research and development. And by virtue of the employment contracts, there's generally going to be an assignment of all intellectual property to the employer. So you need to show proof that the rights from the inventor have been transferred to the applicant. And that will be by submitting a copy of the employment contract that shows there's a clause that relates to intellectual property rights that are being assigned, or a separate deed of assignment document should there be no such clause in an employment contract, or if there's a consultancy agreement perhaps. But any proof that is to the satisfaction of the registrar that the rights have transferred to the applicant must be submitted in support of the application. Then you need to file your P6 or P26, which is the cover page of the patent specification. And then obviously your specification that is submitted with the application, and then any drawings if you so choose in order to exemplify the invention. So drawings aren't compulsory, but if it is there to exemplify the invention, then you should submit the drawings. And then an abstract, so a brief summary of what the invention relates to must also be submitted on the Form P8, as well as a publication drawing. publication drawing is also optional. And the reason why this abstract and publication drawing is submitted is so that if you one day wish to see whether it is a possibility to file an application in the country, you can conduct a preliminary search before filing an application. And you'll generally look at different abstracts within the patent class to see whether or not there is an invention available like that or not. And just to guide you as to whether you will have a valid invention down the line. So if we then look at section 33A, this was an amendment that was made and only came into force in 2007. But this requires that a declaration be lodged stating whether or not the invention is based or derived from an indigenous biological resource, a genetic resource, or traditional knowledge or use. And that, in terms of Regulation 22(1)(EA, is your Form P22. And again, this declaration just attests to whether the invention which you're seeking protection for relates to an indigenous biological resource or biological material genetic resource of South African origin. And that needs to be submitted with every application, whether it's a mechanical invention or whether it's a biological invention. You need to submit the P26. If the invention itself does relate to a South African biological resource or genetic resource or traditional knowledge, then section 33B also kicks into play, where the registrar can call upon the applicant to furnish further proof that they are entitled to make use of that indigenous biological resource or for which protection is claimed. And then they also need to provide further evidence that they are entitled to making use of the biological material, a permit in terms of Chapter 7 of the NEMB or NEMBA Act. They need to provide proof that they have obtained consent to the biological or to use of the biological resource. There also needs to be a material transfer agreement in place, as well as a benefit sharing agreement between the indigenous community and the applicant for the invention, the possibility of co-ownership of the invention, and any other proof that the registrar may require to comply with the use of the indigenous biological resource as an invention in South Africa. Okay, and just to give you some background to this, I'm sure many of you have heard of the Hoodia plant, which was used as an appetite suppressant, so basically a diet pill. And the CSIR caught wind of the properties of the Hoodia plant and the effects that it has as an appetite suppressant. But this was actually indigenous knowledge to the Khoisan. So in times of drought, for instance, the Khoisan would ingest the Hoodia plant to suppress their appetite so they wouldn't feel hungry. And obviously the CSIR saw this as an opportunity to make some money and to sell the product as a as a diet pill. So they then exploited that indigenous knowledge and developed and further extracted the compounds and developed it into this pharmaceutical diet pill and to get onto the market. So you can see that interplay between the indigenous community that holds a lot of traditional knowledge and a company that would exploit it and try and monopolize it, that there should be some form of benefit sharing between that indigenous community so that they can also benefit from the traditional knowledge that they have known for many, many years and which is now being commercialized. And that's the crux as to why the Form P26 was introduced, is to ensure there's compliance with the NEMBA Act, that there is a benefit sharing agreement in place between the applicant and those of Indigenous community. Are there any questions so far? Okay, then again, just touching on Regulation 23, this again requires the assignment of priority rights. Regulation 24 says that if you are claiming priority, you need to submit a copy of the provisional application and specification. It needs to be a certified priority document, so it needs to comply with the certification legislation. And if it is in a language not in one of the official languages of South Africa, it needs to be translated into an official language of South Africa. But in most cases, it will be English that is used. Then every application shall contain an address for service in South Africa, and that is also contained in the Form P3 as the last clause in the P3. Okay, we can move on. So if in an instance the applicant wishes to secure a filing date, but they haven't completed the specification, for instance, but they need that filing date urgently, in order to secure that filing date, they can lodge the application and be given an official number, so patent application number, provided that the application fees paid, that the P1 has been lodged, that there is a specification that is lodged, but in some cases it is possible to do it without the specification and then any drawings if necessary. So provided your P1 or P2 and the specification are filed, you can obtain a filing date. So if the application was not filed in an official language of South Africa, as I said, the translation needs to be lodged as well within 3 months of the filing date in South Africa, or within 6 months for a national phase application. And that also needs to be certified for a convention application. Then Section 37 allows for the priority date to be amended within 2 months of lodging the application. I told you all very boring stuff, this, but we're getting through it quickly. If we look at Section 43, Section 43 uppercase E of the Act deals specifically with the national phase filing of patent applications. And as you can see, it mentions that South Africa has a 31-month deadline and that they need to file the application before that deadline in South Africa by paying the application fee, which currently is only 590 Rand, so really not expensive. And then if it is in a language that is not English, they need to submit a translation of that application in South Africa, and you can lodge that translation within 6 months of the application. Okay, that you can all have a look through. Any questions? Sorry, I'm just finding my page quickly. Okay, if we turn to Section 31, from what can you claim a prior application? Where can you claim a valid priority application or a date to that priority application? So it can be a provisional specification, so where a provisional application has been filed, you are able to claim that priority date. Or if it is an application where a complete has been filed but doesn't claim priority, then you are also able to claim priority from that complete specifications filing date. Then provision is also made for a claim to priority from a convention country, again, following the requirements of the Paris Convention, so it has to be within 12 months. But this I'm going to leave to you just to have a read through yourselves as well. Just very important to note from section 32(1)(a) is that an application from which priority is claimed must be the first application for subject matter in that country. And there's often an issue that arises from the United States where they will file a continuation in part application. So they'll file basically improvements or divisionals on their patent in the United States, but then claim the priority date from that continuation in part application. But in fact, it isn't actually the first application where that subject matter is disclosed. And that can then lead to a big problem in terms of the P3, because they're making a declaration that their claim to priority is valid in that it is the first application where that disclosure has been made, but in fact it isn't. And that can lead to a revocation of the patent in South Africa. But we'll touch on that a bit briefly later on as well. If there had been an earlier application for the subject matter, but to maintain a valid claim to priority of a new application, you must ensure that that first application has been withdrawn at the patent office. So you need to formally withdraw that application, either abandon it, or it must have been refused by the patent office without it becoming open to public inspection. And that you must also ensure that there are no rights that are outstanding on that application. But this will all become a bit clearer to you tomorrow when we work through the examination paper. So don't feel too puzzled about this section just yet. We'll recap on this one tomorrow. If we look at section 32, what is required to be contained in the patent specification? In terms of section 32, it must indicate whether it is a provisional or a complete specification. It has to commence with a title, so you need to indicate what the title of the invention is on the patent specification document. The provisional specification, as I mentioned, doesn't need to contain a set of claims, but it should fairly describe the invention. So you should disclose as much as possible of the invention in your provisional specification. But the complete specification must include the abstract, and it must sufficiently describe, ascertain, and where necessary, illustrate or exemplify the invention and the manner in which it is to be performed in order to enable the invention to be performed by a person skilled in the art. So you have to have a disclosure that will enable a person that is skilled in that specific art, in that technology, to be able to perform the invention that is disclosed. If you fall foul of this requirement where there's insufficiency, so you don't sufficiently describe what the invention is or how to perform the invention, then the patent is open to attack and capable of being revoked on the ground that it doesn't sufficiently describe or illustrate the invention in order for it to be performed. And that is what is known as your insufficiency. So it's very important that the patent document, although very technical, does sufficiently describe how to perform the invention, so how to manufacture the products or what the product is, so that whoever is skilled in that art is able to pick up the documents and be able to proceed themselves were they in that position to do so. Then most importantly, the specification needs to end with the claims or the claims defining the invention for which protection is claimed. The requirements for the claims must relate to a single invention only. They should be clear and they must be fairly based on the matter disclosed in the specification. Okay, so very important. The claims can only relate to a single invention. They must be clear and they must be fairly based on the description and the contents within the specification itself. Okay. If an invention or a patent application contains claims that relate to more than one invention, as you'll see tomorrow, it's not a ground of revocation. So there's no remedy for somebody to attack a patent on the basis that it contains more than one invention, but it could potentially lead to clarity issues down the line. But we'll touch more on that tomorrow. Okay, the rest I'm going to leave up to you to read through. And the same with this section, you can also work through that section on your own. Okay, if we then move on to section 38, this deals with the conversion and post-dating. So this is where you convert a complete application into a provisional application. So this would occur where an applicant hasn't filed a priority application, but they filed a complete application directly, and they then realize that they do want to buy a bit more time. So then the option does exist for that complete application to be converted into a provisional application, provided the requirements are complied with in terms of section 8. And that is that you can't, sorry, let's just have a look at this bullet first. Okay, so the conversion of the complete can take place any time before the acceptance of the application. So you can request to the registrar to convert the application from a complete to a patent, provisional patent, within 12 months of the filing date of the complete, but also to ensure that the request is made before the application is accepted. Then the option also exists to post-date an application, a complete application. So that is where you move forward the lodging date of the patent application. And this can only be done in instances where it is not done more than 6 months after actually filing the complete application. And also that if you do post-date the application, that you do still have a valid claim to priority. So you can't go beyond that 12-month priority period, if that makes sense. So if you are post-dating, you should still have a valid claim to priority. And remember, in terms of Paris Convention, it has to be that 12-month period. And then also, no post-dating can take place on an application where any rights are left outstanding. So moving on to section 34 and regulation 40, as I mentioned earlier, the South African Patent Office doesn't conduct any substantive examination, but they merely just examine the application to check for compliance with the formal requirements for the patent application in South Africa. So I expect a lot of amendment to the Act to take place around section 34 with the introduction of substantive examination. So this will probably be amended quite substantially to allow for the South African Patent Office to proceed with substantive examination. The rest we've already touched on. This slide you can also work through in your own time. So this is just more on the regulations and what is required in terms of the complete specification and the application. There's nothing really much more that I can add to this slide than what is already contained within it. Okay, if we look at section 40, the lapsing of application. So in terms of section 40, the application should be accepted within 18 months of the filing date of the application. So you'll remember from the earlier illustration I showed you with all the various blocks that the formality requirements need to be complied with within 18 months of the filing date. However, in terms of the Act, this 18-month period is reduced to 12 months for national phase patent applications. So instead of 18 months, the national phase application needs to comply with the formality requirements within 12 months of the South African filing date. Okay, so just remember this distinction between a convention application and a national phase application. If the application is not in order for acceptance, so you haven't complied with the requirements in terms of the Act, then the application is deemed to have lapsed, unless there is an appeal filed to the registrar or the delay in issuing the acceptance notice is not due to the omission or act on behalf of the applicant. So the patent office is often overburdened, handling all the applications coming through. And it may be that they don't accept an application at this 18-month period, but they might accept it a few months after that. Where that application is accepted afterwards, it has no bearing on the rights of the applicant. So they still have a valid application because it's the delay in the acceptance notice issuing is not on part of the applicant. Lufuno, you have a question?
Yes, can you hear me?
Yes, I can hear.
Oh, that's good. Okay, I have a question. Sorry to take you back to the previous slide. The convention and the
Post-dating, this one.
yes.
Okay.
So Marco, does this occur on the patent application?
Sorry, what's your question, Lufuno?
I think that the convention, you said it occurs on the complete patent application when you want to convert it to provisional.
Yes, so this is in an instance where the applicant has filed a complete application and they wish to convert it to a provisional application. Then the section 38 over here is the section that is relevant to converting from a complete to a provisional. But obviously it has to be before the application is accepted, and also the document couldn't have been made publicly available. So there mustn't have been any disclosure as well if you are converting from a complete to a provisional application.
Okay, and for the post and dating, it's also for the one during when the complete patent application.
So the post-dating is also for a complete application. Some people have used this provision before, and it's debatable whether it is possible to post-date a provisional application. So some people have relied on this to post-date a provisional application, but whether this provision relates to a provisional application, in my opinion, it doesn't, because of the specific requirements that says that you still need to have a valid claim to priority. That clearly indicates that this post-dating relates to a complete application, in my mind.
Oh, thanks. So what is the negative effect that it has in terms of protection enforcement?
So if you do post-date it, then your effective filing date is moved forward, or rather to a later date. So your rights will only be granted from that post-dated date. So not from the initial filing date, but from the post-dated filing date. And look, I'm not certain what the exact reasons are why somebody would post-date an application. The only thing I can think of is that there may still be some amendments that need to be made to the specification, or they don't want the document to become publicly available just yet, and that's why there could be a possibility of post-dating it.
Thanks, Marco.
Pleasure. Okay, if we then just move back to section 40 regarding the lapsing of applications. So as I said, if there isn't compliance in terms of the formality requirements, in terms of the Act within 18 months for complete or within 12 months for national phase application, then the application is deemed to have lapsed. But there is the option to lodge an appeal to the registrar. And also this provision doesn't apply if the omission is on the part of the patent office. So where it isn't because the applicant hasn't acted. However, as I said, this deadline may be extended. In terms of the Act, you can request an initial 3-month extension of the acceptance deadline. And this 3-month extension will be allowed to you. It is an extension that is granted to the applicant as of right. So if you lodge your request for a 3-month extension, the Patent Office has to allow that application. It's granted to you as of right. If you require a further extension of the acceptance deadline, then you can submit an additional request. So in addition to this 3-month request, you'll submit a request for further extension of the acceptance deadline. Generally, this is only done for a 12-month period at a time. But for this additional request to extend the acceptance deadline, you have to provide the Patent Office with valid reasons why you are requesting this extension. Because the Act specifically refers to this requirement that good cause must be shown as to why you are requesting this extension. So the further period may be requested provided that good cause can be shown. And the reason why this often happens, because just remember, when an application is filed in South Africa, if you're looking at the broader spectrum of a global market, that application is probably being filed in several countries at the same time. So there might be an application in America, there might be one in Australia, wherever it is in the world. There are probably several applications for the same invention in different countries where an applicant seeks patent rights. But because South Africa doesn't substantively examine the application, applicants will often wait to see what is happening in foreign jurisdictions. So they'll wait to see what is happening in America, you know, because, or even Europe, just as an example, because in those jurisdictions, examination also takes place. And they're also issued with a search report as during the international phase. You know, so if there is a problem that is raised in Europe, then they can address it in the South African application as well. So normally they wish to delay this acceptance of the application until they have received feedback from the prosecution that is taking place in foreign jurisdictions where examination does take place. So that they can, if necessary, amend the South African patent specification to bring it into a valid form, to ensure that it complies with the novelty requirements and that it is inventive. Okay, Kimberly, you look lost. No, okay.
My eyes are getting tired.
Okay, mine too. So I hope everyone understands that. So you need to consider this all quite holistically. is that there are different prosecution stages taking place across the world. And often in South Africa, the applicant will decide to delay acceptance to see what is happening overseas in order to bring the South African application in line with what the examination has found in one of the foreign jurisdictions. And generally it will be in Europe, because South African patent law very closely follows the European practices. Okay, then in terms of Regulation 44, as soon as the registrar is happy that the application is in order, he will then accept the application, provided there is no request to delay the acceptance. And he will then issue the notice of acceptance. As you can see here in section 42.1, where the notice of acceptance is issued. And the notice of acceptance will contain the date of acceptance and then also the details of what are required in terms of the publication. And as I mentioned earlier, in terms of Regulation 46, the acceptance needs to be published within 3 months. Very importantly, if it is not published within this 3-month period, the application will lapse. Okay, and these aren't calendar months, so it's actually from the date the application is accepted, if that makes sense. So it might be that an application is accepted, say on the 31st of the month, but that the 3rd month patent journal will be on the 27th of that month. You'll fall short of meeting that 3-month requirement to file. So in most practices, the acceptance is published within the 1st or 2nd month of the acceptance date, so as not to fall short of a few days where you lose all the rights. And just an example of the notice of acceptance that is issued to the applicant once the application has been accepted. Okay, you'll recall that I mentioned a very important case that deals with the publication of acceptance and the requests to delay acceptance or any other requests made to the registrar where there is an extension of time. And the case that we're referring to is the University of Pretoria case versus the Registrar of Patents and Others, which was held again in the Supreme Court of Appeals. That's in the Courts of the Commissioner of Patents. The following was held: that if at the date when the acceptance is due and there has been no request for an extension of that period, and the application is not in order for acceptance, then the patent application lapses. So a very harsh consequence if at the time of the 18-month deadline or the 12-month deadline for a national phase application, if it isn't in compliance with the formality requirements, then the patent will lapse, the application will lapse. And the applicant stands to lose all their rights. And there's unfortunately no remedy to this. This has created a big headache in practice, as you can imagine, for quite a few practitioners. As you can see, there's also no possibility of extending the period of acceptance further after the date when the acceptance due has passed. And this is because of the preemptory wording of section 40. So section 40 says the application shall lapse. If we just go back to section 40 quickly. So what this provision basically requires is that any request to delay acceptance should take place before that acceptance deadline is reached and not after the fact. Yeah. Then also, unless the acceptance of the patent application is published in the patent journal within the prescribed period of 3 months, the application shall also lapse. So you have to publish, as I said, within 3 months of acceptance in the patent journal, or the patent application lapses irrevocably. There is also the option to extend the 3-month period within which to publish the acceptance. So it's not a hard and fast 3 month, but if you are requesting that extension of the publication date, then you need to provide reasons, and that request also needs to be submitted before expiry of the 3-month period in terms of Regulation 46. Okay, so you can publish later than the 3 months, provided that the request to publish later is submitted before expiry of the 3-month date. So very harsh consequences that came out of this case. I mean, you can imagine an applicant has expended so much time and money and effort to lose all their rights because they've just missed this 3-month deadline. So very, very vital part in terms of patent practice itself. And just do note, this is a very important case, and there is likely to be some examination on this case. So please do familiarize yourself with this case, what the facts of the case are, what the findings were as well. Okay, so when does the application become open to public inspection? So as we said, for national phase applications, by the time it enters into South Africa, that application would already be made publicly available because it is published during the international phase already at 18 months. But say the applicant didn't file via the PCT, if it is a South African application with a South African priority, then the patent will only become open to public inspection once the application is published in the patent journal, or rather once acceptance is published in the patent journal. So the documents and the file at the patent office remain a secret document until the date of grant, when anyone is then freely able to access the contents from the patent office for that application. However, if it is a Paris Convention application, so an application that stems from abroad, the application will become open to public inspection within 18 months from the priority date. So unlike with the South African application that will only become publicly available on grant, if it's a convention application, on the 18-month date from the earliest priority date, it will become a public document. Lufuno, I think this was a question that you asked earlier this morning regarding the publication of documents. So that is regulated in terms of these sections.
Thanks.
Okay, section 43, the next section, I'm not going to touch on that. You can just have a look at in your own time. If we then look at section 44, which relates to the sealing and grant of the patent, section 44 states that the patent is to be sealed as soon as practicable after publication. Practicable, I mean, I guess they mean as soon as possible after publication. So this means that they need to issue the letters patent document as soon as possible from the date of publication in the patent journal. And then, as I said, the patent has effect from the date of that publication, so your rights are granted from that date. But obviously there is that retrospective monopoly that exists from the date of filing the application. Just important to note from an infringement or litigation point of view is that you aren't able to, or nobody's able to, the patentee is not able to institute infringement proceedings within a 9-month period after the date of grant. So there is a moratorium period placed on when infringement proceedings may be instituted for the infringement of the patent. So if I, as the patentee, find that somebody is infringing my patent, I can't institute infringement proceedings until expiry of this 9-month moratorium. However, this 9-month moratorium may be waived on leave from the Commissioner of Patents. So you could apply to the Court of the Commissioner of Patents to waive this 9-month moratorium in order for you to proceed with infringement proceedings. But again, it has to be on good cause shown. So there have to be valid reasons as to why this 9-month moratorium should be waived. Just so that you can see what I'm talking about when I'm referring to the publication of acceptance in the Patent Journal. This is just an extract from the Patent Journal, from the May 2017 journal, setting out the patent number, the date of application, or the priority dates, the date of application, the class, who the applicant is, the inventors, the priority details, the title of invention, the abstract, and then the publication drawing. So this is what's published in the Patent Journal. And once this is published, your patent has been granted. Is everyone tired? Raise of hands, who's tired? No hands. Okay. Yeah, so it is quite a bit to take in. We haven't gotten to where I wanted to just yet. Let's see. Okay, now for this, I think we need fresh minds. So let's kick off from here tomorrow, and we'll complete this section then tomorrow, starting from the patents of addition, because this is something that you have to be a bit more awake for and have capacity to absorb. Are there any questions on anything we've discussed today so far? Hi, Bianca.
Hi, Michael. I'd just like to know, the papers are going to tomorrow. Will it be 2019 and 20 paper?
Yes, that's right.
Did you send that to us?
I did email it to you.
Oh, okay.
Yeah, so just check your last email. You should have received them.
Thank you.
Pleasure. Naveen?
Hi, Marco. Sorry, I just wanted to find out, would it not be possible to maybe have a longer class tomorrow with just a few more breaks in between? Because I think that might help, because today towards the end, I found that I wasn't really
Okay. Yeah, that's fine.
grasping as much towards the end.
Okay. Look, as I said, the work from after lunch today was quite boring stuff. But okay, I'm happy to include more breaks tomorrow.
And maybe we can go on a bit longer. I think that might help us.
Yeah, look, we'll have to complete all the work tomorrow, so there will maybe be a possibility of it taking a bit longer, especially if we are working through the exam papers as well. So please just do prepare yourself that we might go a bit over time tomorrow.
Thank you.
Thanks, Naveen. Any other questions or suggestions, should I say? Okay, well, that will be it from me today. I thank you all very much for attending. I really do hope that I am conveying as best as I can the knowledge necessary. So if you do have any questions, you've got time this afternoon to go and recap and to rethink what we've discussed. And then tomorrow morning, we can have a quick touch base session just to see if there is anything that I need to recap on today. as I said, please just do have a look at those past exam papers for tomorrow, and we'll work through those then before the end of the day tomorrow, just so that you are a bit more familiar with the types of questions and the manner in which the questions are asked and what's expected. So thank you all, everyone, and have a good afternoon. Please don't disappear tomorrow. I hope I haven't dissuaded you to attend, but tomorrow is a bit more riveting, more interesting type of work as well. So I'll see you all tomorrow. Thanks, everyone. Cheers.
Thank you.
Thank you.
Thank you.
Thank you.
Pleasure. Thank you.